All right, it is 11 o'clock, so let's get started. Welcome to our webinar. This is on some interesting SRC cases and tips on dealing with GRAMA appeals. My name is Rebekkah Shaw. I am the Executive Secretary for the State Records Committee. I've been in this role since February 2020. It's a little bit of a virtual meeting baptism by fire along with a lot of you, right? And so the State Records Committee now always meets in a hybrid format, so people can attend in person or virtually, which is kind of nice. Anyway, so we're going to go over some of the deadlines when it comes to GRAMA requests and appeals, and some tips on what to look for when you get an appeal and when you look at the request that has been appealed to you, and some ideas on ways to save headaches later that would make GRAMA requests and appeals easier, hopefully a little faster to deal with, and some interesting cases before the SRC. If you came last week, then a lot of this will be there'll be a lot of overlap, but it won't be exactly the same. So I appreciate you coming. First of all, we got a poll. So there are a couple shapes down on the bottom right corner of the screen, and that's where the poll is going to be. And I just want to get a feel of what you deal with when it comes to GRAMA appeals. Do you get about 1 a month, 2 to 15 a month, more than that? Should I be asking how many you get a week instead? See the little shapes down in the bottom corner. If you click that and go to polls, and then the poll will be there. And if you can't find it, you're welcome to put it into the text box. That works too. And also, as we go along in this presentation, I'm not actually much of a fan of PowerPoints. So if you have questions, comments, feel free to unmute your mic and comment and talk, put something in the text box. And I would love for this to be more of a discussion rather than me just talking to the screen, right? All right, what do we got for the polls? About 1 a year. The appeals go to the city. Oh, so you don't know. That's interesting.
I'm dying to know what the poll says.
Yeah, I'm waiting for it. Oh, there we go. I have to actually vote to see the results. Okay. All right, so we've got, I'm going to close this out. Looks like everybody is in A or B, about 1 a month or 2 to 15 a month. Okay, that's interesting. 2 a year, really? Okay. Well, that's interesting. So if you get just a couple a year, when that appeal comes in, does it create a little bit of a panic? Because I find with people who don't get GRAMA requests very often, they sound more anxious when I talk to them on the phone than people who get multiple requests a week and it's just become part of their daily routine answering record requests. Yes, panic. I'm sorry, Craig. Hopefully this will help. There's nothing to panic about. It's GRAMA requests and appeals are it's part of the public's right to see what government is doing, and I'll give you some tools that will help you out. I'm wondering also if you have a designee, and based on the first poll, I wonder if most of you don't, because I find more chief administrative officers have a designee if they have a lot of appeals coming in, and so it just takes too much time and they need to delegate that. So again, oh yeah, I saw that the last poll said request in the poll. That's because we did a similar poll last week, and so sorry about that, but the answers were the same as far as options. So do you have a designee handling the appeals? I'm going to say D so I can look at the results. We got a little bit of everything.
Hi, Rebecca. So actually, I responded that we have a council answers the GRAMA, but we do have a person that is just exclusive for GRAMAs. Just the answer wasn't there.
Okay.
My assistant is just somebody separate that just do GRAMAs.
Okay.
Yeah, we have the same thing, Dorian. There's somebody designated and that person writes the responses. It's not council, but it's not me either. And that option's not there.
Yeah, and it's not my designee.
Okay, I did not think of that when I made the poll. Okay, that's interesting. Okay. A lot of the appeals I get, I've talked to the CAO before, and I know they didn't write the denial to the appeal, and it just sounds like a legal brief. And so that's anyway. Okay, so you have somebody else. All right, let's go to. All right, so for the chief administrative designee, this is the person that is assigned by you, the chief administrative officer, to answer GRAMA appeals. And my tip and suggestion is that this person should not be the record officer. The record officer is somebody who is answering the record requests, right? And so if it's appealed to the chief administrative officer, it is what's a good word? A lot of requesters get suspicious or confused about why the same person is answering the appeal that answered the request. And it feels, when I look at the appeal, it just feels like a big lag when the same person is answering the request and the denial. It just feels like we added a month for no reason. And it's the same eyes looking at the appeal. So my recommendation, if you have a designee, don't designate the record officer. They're already the record officer. And you can designate someone to answer the appeals. And so that's the designee. It's not actually defined in GRAMA, but a designee is mentioned, and that's about it. We had someone say, yes, it's a conflict. Yes, I agree. If someone else has appeals going to the executive director, that's great. Okay. I've got another poll for you. And this will be for a little later in the presentation. I'll go over some records management, but I'm wondering what your records management is like. As a chief administrative officer, this is supposed to be your baby. So if you didn't know you were responsible for that, let's say A. And if you're a chief administrative officer for an agency on paper, but you're really only part of a small part of the entity and you can't really manage everything else, we would love to know. And then you have a RIM team for C. You've got counsel, you've got IT, you've got risk, you've got your record officer, you've got a team for records management. And the last one is that you are the CAO and the record officer, and it's just you trying to do all the things. Oh, you're right. I'm doing some abbreviations. I am sorry. Yes, a CAO is the chief administrative officer. This is the jargon we use, and I forget that people aren't familiar with it. I apologize. So the CAO is the chief administrative officer. And RIM is Records and Information Management. Oh, we got some RIM teams in here. This is fantastic. No one has said A. I am surprised. Well done. That's great. Well done, all. Okay, we've got some RIM teams. And let's see if we have one person so far who just has their little corner, but on paper are responsible for more than that, which is difficult. And Dorian, you have your hand up? If you want to unmute, you are welcome to ask a question.
Sorry.
Yes.
I was halfway through the question, not realizing it was muted. Okay, so I have a question regarding the RIMS. In my brain, I understand the RIMS is the record information management at the archives level. So I have a RIM specialist that I can ask questions to. But when you talk about I have a RIM team, are you talking about a record specialist or information manager within the organization also?
Yes. So I'm thinking of, you have a group of people that you get together to discuss matters of records management. So it's not just like all of your directors or your different project leaders, although they could be on this team. It's more, this is a group that is focused on records management and writes records management policy, maybe the work together to create a fee schedule for GRAMA. It's this team. And it's possible that this team already exists for another function and you could just double it up. That's fine.
Yes, that answers my questions. We do have a committee, but we don't call it RIM committee, we call it archives committee, and it's in the making as many people retired and left. So we are in the putting everything together again.
That's great. See, someone said in the chat that they've been the ARO, and, the record officer, and the CAO for records until recently when they got another records manager. That's great. Having record managers, great. So that means you're the chief administrative officer and you have a new records manager who is the appointed record officer, or is it vice versa now? Okay. All right. Both handle records. Okay. That's great. It's good to have the CAO and the record officer know each other and be able to work together. That's fantastic. All right. I'm going to go over some of the deadlines. And so hopefully this makes sense. So we've got, when your record officer receives a request, they need to answer as soon as reasonably possible, is what GRAMA says, but no later than 10 business days. 5 if it's an expedited request. And for something to be expedited, it should be something that is going to benefit the public. And it's kind of up to you. If someone has asked for for a request to be expedited because they have a court date coming up, they really need the records as soon as possible because they need the records for something, and so they've got a deadline. That's fine, and it's up to you or the record officer if they're going to answer it within 5 business days as an expedited request. And then after, if it's denied, then the requester has 30 days, calendar days, from the date of the denial to appeal to you, the chief administrative officer. And when they get the denial, the record officer should put in who they can appeal to. And I've seen appeals or responses to requests where they got the records and it still let them know who to appeal to if for whatever reason they feel like they didn't receive all the records or were unsatisfied with the response. And so it would say something like, in as much as you feel that records have been denied, or you can appeal to the chief administrative officer at this name, this address. which I think is a good practice, so that they always know that they have the right to appeal. Anyway, so 30 days, calendar days, and then the appeal needs to come to the chief administrative officer. If it's after 30 days, then it is untimely. You can still answer it if you want to, but then the calendar keeps going. This timeline keeps going. If you tell them it's untimely because it's after 30 days, then you don't need to answer the appeal. And if they appeal it to me, if it's untimely, it's untimely. Anyway, so when you receive an appeal, you also should answer as soon as reasonably possible. But if it's expedited, you've got your 5 business days. Otherwise, the deadline is 10 business days. And if you deny anything, if anything is redacted, if records are not provided, then you need to let them know they have a right to appeal to the State Records Committee or the local appeals board if you're one of those few agencies that have a local appeals board. There aren't many of those, but that is a entity that the requester needs to appeal to before they come to the State Records Committee. Once the requester receives a denial from you, they have 30 calendar days to appeal to the State Records Committee. And then I get those and I go over them, make sure that the appeal is complete, that it's timely, and I need to provide an answer within 7 business days that either denies the appeal because it's untimely, the records don't exist, we don't have jurisdiction, or I schedule an appeal hearing. There are a few reasons why I would deny a hearing. Okay. If we don't have jurisdiction, if you're with the legislature, the courts, then we don't schedule those. But for the most part, we do schedule them. We have a question. If a requester fails to appeal timely, he or she can simply refile the original request, correct? That is true. Someone can submit record requests as often as they want. There is a new addition to GRAMA from this last legislative session on with fees that some interpret to change whether or not you can submit an unlimited number of requests. But you do not have to answer requests that you've answered before. So this gets kind of messy. So if they've submitted a request and records were denied or something was redacted and they appeal to you, but it's day 35 and it's untimely, then you can deny it because it's untimely. And if they submit a new request because they want to restart that calendar so that they can appeal, then you do have the option as a record officer to say, I've already answered this and I don't need to answer it again. And then they appeal to you. So now the question that you're answering is different. But it's up to you how you want to handle that. You could respond and say, I see we've answered this one before. The redactions were made for these reasons, these citations under GRAMA. And I think that would be kind. But you also have the option of saying that we've already answered it before and we don't need to answer it again. So it completely depends on the situation and how you feel it would be appropriate to respond. And it's up to you. And then let them know that they have a right to appeal to the State Records Committee. It all kind of depends on what the question is that you're answering. It's clear as mud, right? I highly recommend in a situation that feels a little confusing that you can give me a call, and especially Rosemary Cundiff. She is the Government Record Ombudsman, and I'll have her contact information at the end of the presentation. She is the go-to person for all things GRAMA and can help mediate appeals from the moment of request up until like the day before the State Records Committee hearing. Sometimes she is still in mediation and working to resolve some things. It's awesome. So anyway, okay. So that's the appeal timeline. And here are a couple other deadlines. The State Records Committee meets on the third Thursday of every month. And we have a lot of appeals this year. It's going to be a record-breaking year because normally last year we had 144 appeals for the entire year. And I'm already in the 120s right now, and it's May. And so it's been a busy year. So the committee has actually added an extra meeting in June. Sometimes we do that just to kind of catch up so we're not scheduled out so far. But I've always let you know when your hearing's going to be. But generally, we meet on the third Thursday every month. And 5 business days before the meeting, so it's basically the Thursday before the meeting, is when a statement of facts is due from the respondent, which really is just, I promise, it's really just letting the committee know what you want them to do and why the records were denied. The State Records Committee is not a court. It doesn't need to be a full legal brief. Just let them know why the records were denied and what you think the committee should do. And that's really all it is. And 2 days before the meeting is the deadline for the petitioner to withdraw. If you feel that the appeal has been resolved and it should have been withdrawn, but it hasn't been yet, I get that sometimes from attorneys and chief administrative officers when they get the agenda and they're surprised, like, I thought this was done. Let me know. I can reach out to the requester and see if they just maybe forgot to let me know that it was resolved. But the appeal does need to be withdrawn by the requester, by the petitioner. If you're still in mediation and would like to postpone, let me know. If both parties agree, we can very likely postpone. It's very rare for us to not postpone it in those circumstances. And then at the hearing, both parties have 20 minutes, up to 20 minutes. You don't have to fill the time if you don't want to. You get up to 20 minutes to present about the request, why the records were denied, and you can bring witnesses if you want. It is fantastic if the record officer attends or somebody who's really familiar with the records and how what is involved in providing access to those. So if the committee has questions, there's someone there who can answer those questions. That goes a long way. And then the committee deliberates. They're in open session, so you know what the decision is before you leave the meeting. And then our council drafts the decision in order, and those go out 7 business days after the hearing. And from that date, there are 30 days for someone to appeal to district court if they want to, if they disagree with the committee, or if the committee granted the appeal and ordered the agency to release some records, then you've got 30 days to provide those records and send the committee a notice of compliance, which is really just an email saying we provided the records and let the committee know. That's it. It's like a sentence in an email that works. Okay, so I got a tip. Some of these might sound like soapboxes, and if they do, I'm sorry. Statement of facts don't need to be treated like a legal brief. And attorneys are not the only ones who can present before the committee. I've been attending the SRC for years, and we used to have record officers present before the committee a lot more often than we do now. It's more likely now to have counsel speaking to the committee, which is fine. I miss seeing the record officers, but it's fine to have counsel doing that for you. That's fine. But I do find that if counsel is doing the presentation, they treat the State Records Committee preparation like they're going to court. And so it's thorough for sure, but it doesn't need to be a legal brief. I don't know what kind of time these take for attorneys, and I hope it isn't more intense than it needs to be, is all this tip is for. The State Records Committee is made up of volunteers, and there aren't any lawyers that sit on the committee. We have a lawyer that comes to help the committee if they've got questions, but the committee is made of volunteers, and so brevity is always appreciated by the committee. Another tip, which I've already mentioned, is that you can work with the government record ombudsman at any point. And the best thing about mediation is there's a lot more flexibility to resolve the appeal in mediation. The State Records Committee is limited in what they can do. They can say the records are properly classified. They can say, and deny the appeal. They can say that the records are properly classified, but there's a lot of public interest, and release the records. But in mediation, there are a lot more options that are available to satisfy the requester, and then you don't need to have a hearing. Maybe the requester just wants to have an affidavit saying something, and then they'll withdraw the appeal. And that's not something the committee is going to do. But you could do that in mediation. So anyway, lots of options and in mediation. So before I go any further, oh, wow, time's going by really fast. I was wondering what you wanted to hear more about as far as some tips. Do you want to know about the fees, classifying the records, or how to send a denial if that's something that you don't deal with very often, or maybe something else, and you can put it in the comments. So again, go down to the shapes and click the polls and scroll down. And I got a vote. Okay. Determining what can be provided. We've got, ooh, people voting. People are still voting. All right, it's looking kind of split between calculating fees and determining classification. And a few votes how to answer a request with a denial or a partial denial. And if you voted for something else, please put it in the comments, and we'll try and make sure we answer everybody's questions. Okay, well, I'll try and run through all the things. So let me get rid of these notifications. Okay. So one thing to look for, questions for information are not the same thing as a GRAMA request. So if someone says, what is your policy for social media? That's not exactly the same as I would like a copy of your social media policy. The answer may be to just send them a copy of the policy. But a lot of times people are using GRAMA and they're asking a question. They're not really asking for records. And so we kind of need to look at it like Jeopardy. Is the question in the form of a record, right? And so if it's just a question, they're not actually asking for records, then the whole timeline doesn't really apply. And it's just providing customer service, but it's not really a GRAMA request. So a request is defined in GRAMA under 63G2 2041. And okay. Yes. So when you get the appeal, you're going to receive a copy of the request. And when you see what they're asking for, do you understand what the request is for? The GRAMA says that a request needs to be reasonably specific. And so this is kind of how we define it at the archives. If you understand what they're asking for, then it's reasonably specific. It might be voluminous, but it is reasonably specific. If they did they ask for a fee waiver? So if they did not ask for a fee waiver with the initial request, but the record officer responded saying this is going to take this much time and it's going to cost this much, at that point, they can appeal the denial of a fee waiver, or can ask for a fee waiver and an appeal to you as the chief administrative officer. And that's okay. They can do that. If it's something that has already been provided, the record officer doesn't have to provide it again. It's kind of up to you guys how you want to handle those. And one big thing, GRAMA says that you are not required to compile, format, manipulate, package, summarize information for a request. but you may. It's a big may. And it seems whenever an entity has done this and comes to the State Records Committee saying we provided this and this, we created this just to try to answer their question because we couldn't provide the record that they were actually asking for, that goes a long way with the committee to see that you've done everything that you could to provide, to help them find what they were looking for. And a big thing, you cannot use the physical form of a record to unreasonably hinder the rights of a person to inspect a record. If whenever someone comes to the State Records Committee and they say they cannot provide access to the record because it's in a database, because it's electronic, the committee almost shuts off. They find that very frustrating. And so it would be very good in those cases, if you feel like there isn't a way to have an output to answer this request, to have somebody at the hearing who understands the system and what options are available to create an output for a request so that those questions can be answered. Because we're in the digital age and requesters expect anything electronic to be easily accessible and provided, right? And the committee also expects that there is some form of output. And so if you can't provide access to something because of the format that it's in, make sure that I would recommend, this is not a slide for a tip, but I would recommend in your response to the requester, explaining as best you can what you've done to search for the record and why you can't get it. So it goes a long way for customer service to just help them understand what you can and can't do to answer their question. And so is that. Oh, and also when it comes to things that you've already provided, one thing in 63G2 204.8D, you don't have to fulfill a request if it unreasonably duplicates a previous request. And so the word unreasonably kind of makes things different. That kind of answers whose question it was earlier. It says unreasonably. So if it's and that is up to you to interpret if it's reasonably duplicates a previous request. If they're sending the same thing over and over and over again and it just becomes obnoxious, then that's something else. But keep in mind, when people request the same record, but the time frame that they're asking for is different, it's kind of a different request. Or it is a different request because the time span is different, so the records will be different. Anyway. When you receive an appeal, respond to the requester and let them know that you got the appeal and that you're working on it. I get a lot of appeals that the requester just didn't get an answer at all. Sometimes it's because it got lost somewhere, and so the record officer never got it, the CAO never got it, and I try to check to see if it was received. But if you don't respond at all when it comes to me, I will schedule a hearing. But it's just little customer service stuff. These are some things that members of the committee kind of wish people would do. And just let them know that you got it and that you're working on it. And especially if it's something that's going to be a little involved, you need to talk to counsel or IT and get some sense of what it would take to provide the record. Give them a timeline if you can. It's like, we're working on this. I need to talk to some people. I'll get back to you in a couple days. And then they're not worried that you didn't get it. When it comes to classification, before you spend any time redacting or segregating information so that you can provide what is public and withhold what is not public, check if what is left is meaningful. If it doesn't make any sense, you can deny the entire thing and not spend the time putting in black lines. Does that make sense? And so if it's not meaningful and a requester receives a bunch of pages of black lines, they get really frustrated. And it would save you time, and I think it would be simpler for everybody to just deny access to the whole thing and say, and then you can tell the committee that there's nothing left of any meaning if we provide it with redactions. And we do hear that sometimes. We got a question. I sent a GRAMA request, and the response was only that my request sent back to me with a short note from the records manager that they're not the custodian of any records. As the records manager, are they in charge of finding those records or sending the request to the person who has the records? So when you send a GRAMA request, the denial, I would hope, would say why it's denied and have a citation. If they're responding and saying that they aren't the custodian of the records, but somebody else has them, if you know who has access to the records, it would be great to refer the requester where they can go. If you don't know, let them know that you don't know, but that you don't have the records, or that no records exist in your office that are responsive to the request. That's okay to say. The record, let's see, and the other part of the question was, as the records manager, are they in charge of finding those records or sending on the request to the person who has the records? So they can respond and and say that they have forwarded your request to another office. But if it's another office, if it's another office within your own entity. So if you're part of a big department and you got a request for this division, you're the record officer of this division, but the request is for another division, they can just forward that and either let you know or forward it, and then you get a response from another division record officer. That works. If it's a completely different department or from one city to a completely different city, they might just tell you, we don't have the records and you need to ask the other city. And then the requester needs to ask the other entity. And both of those are correct. Just kind of depends on the request and the entity, which I hope that helps. Okay, so another thing for classification, GRAMA sometimes just feels kind of baffling, because under 63G2 of records that are public, and there's this whole bit of records that are normally public. And so this normally public would mean the record may have information that is not public, but generally the record is public. There might be some redactions that may need to be applied. And under 63G2 which is private records, there's this whole list of things that are private, and then things that are private if properly classified, which means you as the respondent have discretion, and you got to look at the records and see what you think, if it's private or not. The citation we see most often at the State Records Committee is that something would be an unwarranted invasion of personal privacy, which is a big bucket, and it's completely your discretion if you think it would be an unwarranted invasion of privacy to release the record to a requester. So another tip for classification, governmental entities have the duty to designate and classify their own records. You don't have to have the same classifications as another entity, which when we have a lot of times there are record series on the archives website that will say how long the record is kept and what the classification is. And that doesn't mean all the records about this have to have that classification. You still need to look at the record when you get a request and see what the classification is. And you may have very similar records to another agency, but your processes are different. So the records are a little different and the classification may be a little different. That's fine. They're your records, and you know your records and processes, right? So every request needs to be individually analyzed and carefully considered. And so make sure you look at the records, and that and a record can have more than one classification, which is what segregation and redaction is for. So a couple of tips and tricks to save you headaches later. This is all records management stuff. The better your records management is, the easier GRAMA requests and appeals are going to be. Okay. If you haven't checked it out yet, 63A 12103, that is you. That's the Chief Administrative Officer, and the list of 10 things for the Chief Administrative Officer to what you're over and responsible for. And your record officer, if you have an appointed record officer and you appoint the record officer, be their ally. A lot of record officers are doing their best to manage records, and they really need your buy-in and your support so that they can work with the other divisions and other coworkers and employees that actually create records to make sure that everyone understands what the proper practices are to manage records, and to understand what everything is, where everything is, so that when they get a request, they know who to talk to, they know where to go and where the records are. Better records management means record requests aren't painful, and you don't need to panic because you know where things are and you know what the classification is. So hopefully you have a RIM team and you're familiar with who is responsible for what and what the agency does, all the processes, the systems, and you've got your subject matter experts. So a RIM team, if you don't have one, make sure the record officer is at the table. They need to be there. They have been appointed to be the liaison with the archives for all things records when it comes to scheduling and preservation of records. Have someone from HR. We get a lot of record requests for HR come to the State Records Committee. IT, administrator for the different systems and databases that you have. Risk management, have your counsel there, and all your subject matter experts for the different projects and things you have going on. Make whoever you need to have on that team, get them together, and that is your records and information management team. And if this is something that doesn't exist yet, you're the Chief Administrative Officer and you're responsible for the records management of your agency. And if you get this kickstarted, it would be so powerful and it would be awesome. And you could have the record officer as your designee going forward if you can't attend the meetings all the time. But you can give the record officer the authority to make some records management decisions, and we can help you and the record officer with that. This would also really, and again, really help the record officer when they get a request to know, one, if the record exists at all in the first place, and where to go to see if you have an open investigation, if it's something that's being used, if it's something that is stored off site, all the things, right? And this is something that I've heard from members of the committee. This is not a requirement, right? This is a tip and / soapbox. But when you get an appeal, when you have a request, let them know how you conducted the search. It is not uncommon for an appeal at the State Records Committee to have a requester convinced that you haven't looked everywhere, and the committee has on occasion had a decision saying the records are properly classified, but we recommend that the agency look again. And so if you can say up front how you conducted the search, it goes a long way with the committee. But also, if you tell the requester how you search for the record, then maybe they can say, oh, that's not really what I mean. And so can you try these search terms instead? And then you can have a dialogue with the requester. And that will help satisfy the request and will help in mediation. Okay, fees. You may charge a reasonable fee to cover the actual cost of providing a record, and it needs to be approved by the executive officer, which is probably you, right? And so it's not uncommon for entities to create something to respond to a request. And if you have an ordinance that has extra procedures or certain things that the requester needs to do, let them know what those are and send them the fee schedule so they know how much things are going to cost. I've seen some agencies that have request forms on the website and it has the fee schedule with it. I think that's awesome. Also with their appeals. So when the requester is filling something out, it says how much things are going to be per hour, how much copies are. And I think that's fantastic. So they already have an expectation of how much the request could cost. And yeah, and so it's the actual cost. What the actual cost means is staff time. If you're actually going to be compiling, formatting things, because you may, right? You can charge for that. Search and retrieval, administrative costs, you can charge for that. And incremental costs of providing electronic services and products. For some of you, you might not actually have someone on staff that is overseeing certain systems, and so it's all done by a third party, and that's what the charge is going to be. That's okay. And if you for the hourly rate, remember that it is the hourly wage of the lowest paid person who could do the work, which isn't always the person who actually is doing the work. And so as part of your records and information management policy, I highly recommend you have a fee schedule approved by everybody that's reviewed and just part of your policy, part of your records management policy. It takes a lot of confusion away, especially when we've had one appeal with Jennifer Orton in Salt Lake County, and she was charged it was over $1,000, and she had tried to break down how the cost was I've just lost the word. Anyway, she had tried to break down what everything cost, so it came to that total, right? And she brought a witness to the hearing who had requested the same records but was charged something else. And they didn't really understand the fee. And I think if there was a fee schedule, it would really clear out the confusion so that the requester understands why things cost what they do. And never, ever, ever, ever use fees as a deterrent or just charge a fee and have that be the denial. You still need to let them know they have the right to appeal. And I don't know that anyone's ever actually done it, but there has been speculation by some requesters that maybe that is why some fees are expensive. And so I just want to make sure we're clear. Don't ever do that, because if you have a high fee and you don't think they're going to pay it, if they do, then you've said you will provide the record for this cost. And so make sure that when you're calculating your fees, you know what the time's going to be, and it's actually something we're willing to do it for this much. If it's really expensive, I would also recommend reaching out to the requester and letting them know this is going to be a lot of time. It's going to be really expensive. Can we narrow the request so that it's something a little more manageable? And that might be a better way to go than to say the fee is going to be $10,000 or something. Anytime anything is withheld for any reason, that is a partial denial or a full denial. Something has been denied because something has been withheld, right? And so if you redact anything, let them know they have the right to appeal in your response. And so if you have any questions about creating a records and information management team or creating a fee schedule, these are your allies. Whoa, as I skip a slide, here we go. These are the records and information management specialists at the State Archives. Hopefully you already know who your RIM specialist is. And Avalon is over special districts and schools, universities. She's got some state agencies. Heidi Steed is over local government, law enforcement. Renee has a lot of state agencies, elected officer agencies, and Matt Pierce also has state agencies. So if you're with a state entity, check our website to see which analyst works with your office. Matt Pierce is also over the general retention schedules. If you're wondering how long certain things are to be kept, he might be your go-to person. Okay. A little bit of time left. I'm going to go over a couple appeals. An appeal does not mean you did anything wrong, okay? I promise. It's just the public has a right to appeal if something's been denied, and so they come to the State Records Committee, and that doesn't mean that you did anything wrong. It's just part of the process with GRAMA. Oh, we have a question. If I am responding that I am not the custodian of the requested records, I provide contact information for the appropriate entity. Do I need to include language for appeal? You don't have to. You don't have to. You could, if you want to adopt the practice of including that appeal information on all of your responses, just so that they know, then you could. But if you don't have the requested record, if you're not the custodian and it belongs to another entity, then yeah, you're redirecting them. It's not exactly a denial. They could appeal, and then the chief administrative officer will say the same thing, right? And if they appeal to the State Records Committee, you don't have the records, and we probably wouldn't schedule the appeal either. So yeah, so I would just, as long as you're super clear about you don't have them, and as you said, you provide contact information of the appropriate entity, I think that's perfect. This Anisco versus Attorney General was from a hearing last month. The requester had asked for the records from two different entities, the Attorney General's office and the Division of Risk Management, and received these records from the two entities. They didn't talk to each other before providing the record because they both had the records as part of their own processes, right? They didn't have a shared record agreement or anything. And so the redactions were a little different between the two. And the way it was kind of described was like the record had some columns, and the middle column was redacted from both of them, but the other things were a little bit different. And so the requester felt like one of them wasn't being completely honest with the redactions, and there should be less withheld because they got some information from risk management that the Attorney General's office didn't provide. And neither of them actually really did it incorrectly. The overlap was correctly redacted according to the State Records Committee, that they determined that the records were properly classified. And so anyway, it was an interesting discussion with the committee when two different entities had provided the records in different requests, and the redactions were different, and it happens. It's okay. It doesn't mean either of them responded incorrectly. Rosenstein versus UDOT. This one was interesting because the requester had asked for records related to a contractor, and it was voluminous. It was so voluminous. And so while the respondent was still trying to get things together and pull all of the responsive records, the requester had appealed what they had already received. And by the time it came to the State Records Committee, the committee felt like this isn't done yet. You guys are still going through records. You're still pulling the records, and the committee's not going to do that for you, right? And they're UDOT's records. UDOT needs to finish going through them and classifying the records themselves, and the committee's not going to do that. And so the hearing was continued several times because it was a voluminous request. And the last time they came to the committee with the records that were left classified as non-public, and the committee went through those and determined if the redactions and classifications were proper. And well, that they were. There were drafts, there were attorney-client privilege things, all kinds of stuff. And so the committee's not going to go through all the records for you and decide if it's responsive or not. They're really there to determine if something has been withheld properly or not. So, O'Neill Chambers versus Orem City. This one also kind of felt a little bit like a shared record appeal, but not quite. Mr. Chambers was asking for a police report where he was the alleged victim. Sorry. And so the incident happened at Alpine School District, but Orem City had the investigation report. And so they had provided some records. He appealed to the chief administrative officer, and the chief administrative officer looked at the request and decided some of these we can release to you. That's one thing that's nice about a chief administrative officer appeal, is that you have more flexibility than the record officer does in what to release to the requester. You could reclassify some records that the record officer decided were not public and say, in the public, due to public interest, we're going to release these to you. The record officer can't make that decision without you. That's something more at your appeal level. And so these records, there were two things left after the CAO appeal that had been withheld, and the committee determined that they would have been an unwarranted invasion of privacy. There were some witness statements, and so those were properly withheld. And I've already said this, but just adding that to my tip. It's not a court. It's nothing to be intimidated about, and the committee's made up of volunteers. We have the state archivist here. We got 7 people and 2 citizen members. Marie Cornwall is a sociologist, Dr. Cornwall, and Nova Dubovic down in the bottom middle. She's also a citizen member. And then we have a media representative. That's Tom Haroldson right now. And the Utah League of Cities and Towns appoints a member to the committee. That's Nancy Dean right now. She's from Clearfield. We have a private sector records manager and a member with experience with electronic records, and that's Ed Beeler. He's a police chief for Bountiful. And we get a lot of requests for law enforcement records, a lot of appeals, rather, for law enforcement records. So it's really nice having a police officer on the committee. This one, Tiffany Gilman versus Unified Police Department. She was asking for a cold case file for Nancy Wilcox for a book she was writing about Ted Bundy. And Nancy Wilcox went missing 45 years ago, but the case is still open because her body hasn't been found. And so Unified Police said that it's open, it's an ongoing investigation, so we can't release these because GRAMA says if it's an open investigation, it's not public. So the committee looked at the records and felt that the case was not actually open, but in granting the appeal, there were still some heavy redactions, and so some information was ordered to be released to the requester, but not everything. And sometimes that happens with the committee. They'll grant the appeal, which means something's going to be released, but they can still say there need to be redactions because of attorney-client privilege, unwarranted invasion of personal privacy, or whatever. And I am running out of time. So, okay, one more, okay? Sam Stecklow versus West Jordan Police. This one is at the district court right now. Mr. Stecklow is a journalist who is requesting the records, commonly called Garrity statements, for a story he was working for the Tribune and Frontline. And the committee decided that there is significant public interest in order that these statements be released. And so West Jordan has appealed to district court. And some of the, and the law also was changed this last legislative session. And a lot of, some things can be precedent setting, right? Sam Stecklow requested these records from a lot of different agencies, and some of them provided access to them and considered them public, and others didn't. And the records are different from one agency to another, and so it's fine, right? Records are different, which means they get classified on their own. All right, so this is Rosemary Cundiff. She is the government records ombudsman. She is the superstar. If you've got questions about anything with GRAMA, with appeals, when you get a request, she is your go-to person. You can also call me, and our phone numbers and email addresses are there. Thank you for coming, everybody.